Ladies and gentlemen, thank you. Let me begin by acknowledging the traditional owners of the land that we stand on, the Turrbal people and the Yagara people, and to pay respects to their ancestors who came before them. The location of the State Library on Kurilpa Point was historically a significant meeting place, gathering and sharing place for Aboriginal people, and we proudly continue that tradition here today. Your Excellency, Mrs Penelope Wensley, AC Governor of Queensland, the Honourable Tony Fitzgerald, AC QC, and Mrs Kate Fitzgerald, Professor Hilary Charlesworth from the Australian National University, Griffith University Chancellor Ms Lenine Ford, Griffith University Vice-Chancellor and President, Professor Ian O'Connor, senior members of the University, members of the Judiciary, the Honourable Wayne Goss, the Honourable Matt Foley, distinguished guests, colleagues, ladies and gentlemen. I'm delighted to welcome you here tonight to the second Griffith University Tony Fitzgerald Lecture. My name is Janet Ransley and I'm Head of the School of Criminology and Criminal Justice, which proudly hosts this initiative at Griffith University. 25 years ago, on the 26th of May 1987, a commission of inquiry into possible illegality and misconduct was established in Queensland. 2 years later, in July 1989, it delivered its report. The inquiry had been expected to take 6 weeks. Instead, it lasted 2 years and created the benchmark for future policing and corruption inquiries, not just in Queensland, not just in Australia, but internationally. And it also created the bar against which all future Royal Commissions and Commissions of Inquiry in Australia have been assessed. In 2009, to celebrate the 20th anniversary of the Fitzgerald Report, the Griffith University Tony Fitzgerald Lecture and Scholarship Program was established, and the first lecture was developed here at the State Library by the Honourable Arthur Shackleson. Tonight, we gather here to continue this program and to hear the second lecture in this series. But before we move on to that, it is important, I think, to briefly revisit why this program has been created and what was so special about the Fitzgerald Inquiry. To many of the people in this room, such a reminder is not really necessary. We remember the events leading up to, during and following the inquiry all too clearly. But memories fade and a new generation needs to understand what Queensland was like and why the lasting legacy of Tony Fitzgerald and the team with which he worked is so important. Students now attending our introductory policing and ethics in government courses were born 5 years after the inquiry finished. Why should they care about it? Well, to answer that question, I always say to them that 20 years ago, Queensland was a different place. Public life was marked by widespread police and ministerial misconduct and a gerrymandered electoral system, poor administration and an authoritarian and autocratic style of government. Democracy, accountability and good governance were in very short supply. The Fitzgerald Inquiry was appointed in 1987 in Premier Bjelke-Petersen's absence overseas, initially to investigate quite narrow allegations of misconduct. It quickly became a wide-ranging inquest of the full range of the state's institutional framework, ethics and performance. The inquiry went far beyond investigating corruption to analyse why this situation had arisen in the first place, and it laid fault with the institutions of government. A cabinet and ministers who abused their executive power, and a weak and compliant parliament, public sector, justice system and media, which had all allowed corruption to flourish. The reform program aimed to strengthen these institutions and prevent recurrences of corruption and maladministration. The inquiry really was a cataclysmic event in Queensland governance. It provided a clear dividing point between a pre-Fitzgerald era of corruption and misfeasance and a post-Fitzgerald era of reform. The report itself became a blueprint for this reform. The most enduring Fitzgerald legacy was its focus on systemic and lasting change rather than individual wrongdoing. The inquiry recommended the creation of the Electoral and Administrative Review Commission and the Criminal Justice Commission, now the Crime and Misconduct Commission, and their respective parliamentary committees to overhaul the state's electoral boundaries and voting systems, freedom of information, peaceful assembly laws, judicial review, administrative appeals, independence of the Auditor-General and the Ombudsman, public sector integrity and political donation laws, the operations of Parliament, and not least, the complete renewal of the Queensland Police Service. That's not a comprehensive list, that's just a partial fragment of the scope of reforms recommended by the inquiry and pursued by the two agencies which it spawned. To mark the 20th anniversary of the Fitzgerald report, the Griffith University Tony Fitzgerald Lecture and Scholarship Program was established. As part of the commemoration, a collection of papers by leading scholars assessed the enduring nature of this Fitzgerald legacy. They found that much of the integrity system initiated by Fitzgerald 20 years ago does indeed endure, but that ongoing vigilance is needed to maintain and develop that legacy. This lecture series contributes to that program of ongoing vigilance and to its expansion to consider issues of justice, integrity and human rights on a broader and more global scale. Our speaker tonight will be making a major contribution to our understanding of these issues. But before we hear from her, it is now my pleasure to introduce the Pro-Vice-Chancellor for Arts Education and Law at Griffith University, Professor Paul Mazerol, so that he in turn can introduce Tony Fitzgerald QC. Thank you.
Thank you, Janet. Your Excellency, Penelope Wensley, Governor of Queensland, Miss Lenine Ford, AC, Chancellor of Griffith University, Professor Ian O'Connor, Vice-Chancellor and President, Griffith University, Professor Marilyn McManaman, Deputy Vice-Chancellor and Provost, Griffith University, Professor Sue Spence, Deputy Vice-Chancellor Academic, the Honourable Tony Fitzgerald, AC, QC, Professor Hilary Charlesworth, Australian National University, distinguished members of the Judiciary, distinguished guests, ladies and gentlemen, it's my great pleasure to be here tonight to introduce the Honourable Tony Fitzgerald, AC, QC. As many of you know, Tony has had a very distinguished legal career at the bar and also as a member of the judiciary, and he's made a number of important and significant contributions to both to the state of Queensland and to Australia more generally. Tony was born and educated in Queensland, having studied at St. Patrick's College and at the University of Queensland. Tony's career achievements are many and impressive, and it's really a serious challenge to try to do justice to his achievements in only about 5 minutes, but let me share with you some of the highlights. In 1975, Tony took silk at a very young age of 34. It was observed through the profession at the time that he was an advocate of awesome ability. In 1981, he was accepted as an appointment. He accepted an appointment at the Federal Court of Australia, and he became the court's youngest appointee at age 38. He returned to the bar in 1984 to concentrate exclusively on appellant work. In 1987, he was appointed to conduct the Commission of Inquiry into possible illegal activities and associated police misconduct, more commonly referred to as the Fitzgerald Inquiry. As many of you know, Tony's impressive career did not end with the Fitzgerald Inquiry. Since that time, Tony has conducted a Commission of Inquiry into the conservation, management and use of Fraser Island in the Great Sandy region. And this saw an end to the logging in the Fraser Island, subsequently becoming a World Heritage listed on the World Heritage Register. He also previously served as chair of the Australian Heritage Commission. And after that, with the establishment of the Queensland Court of Appeal, he was appointed its first president and served in that role from 1991 to 1998. He served as a judge on the Court of Appeal Division of the Supreme Court of New South Wales from 1998 into 2001. In 2001, he also chaired the Cape York Justice Study, which involved a very comprehensive examination and investigation into alcoholism and child abuse in Cape York's Indigenous communities. In more recent years, Tony specialized in the commercial and employment disputes as a mediator and an arbitrator, and I've read recently that he's commented that this has been a very worthwhile initiative and he's fully appreciated alternative dispute resolution, and it's provided a nice comparison from the more adversarial tradition we have in our justice system. Now, much has been written about the overall and significant impact of the Fitzgerald Inquiry on public life in Queensland. It's clear that the results of the inquiry influenced the entire institutional framework of this state. As Janet mentioned, the number of recommendations that came from the inquiry led to significant changes in our policing system, our system of governance, and indeed our political system, and provided a blueprint for other states and indeed internationally. Aside from the many and significant prosecutions that came from the inquiry, The report led to a number of major reforms, as Janet mentioned, the establishment of the Electoral and Administrative Review Commission, the Criminal Justice Commission, and the reform of the then-named Queensland Police Force. Overall, the report facilitated the first major reforms of local government in more than 40 years. And it's been observed that no other inquiry before or since in Australia or overseas has had such an impact. The inquiry, the Fitzgerald inquiry, also served as a catalyst and inspiration for many researchers and many practitioners, and this has had a significant impact on Griffith University. And this impact can be seen through the establishment of our School of Criminology and Criminal Justice in 1990, and then the subsequent appointment of Professor Ross Hommel as the Foundation Professor. The school has thrived since its origin and since the appointment of Professor Hommel. The impact can also be seen through the establishment of the Australian Research Council's Key Centre for Ethics, Law, Justice and Governance, which involved the efforts of Professor Charles Sanford, Professor Hommel and Professor Pat Weller, and with Tony Fitzgerald as the inaugural first chair of the advisory board. Tony also served as the chair of the Griffith University Innocence Project Advisory Board, and Griffith more recently strengthened its relationship with Tony in making him a doctor of the university in 2003, and this is an award that he so richly deserved. More recently, Tony has been instrumental in supporting our efforts to further embed his legacy in the form of a PhD scholarship in his name, as well as to provide support to the biannual lecture. Griffith University is most fortunate and appreciative of this association and partnership. We believe the biannual lecture will continue to serve as an important reminder of all Queensland, to all people about Queensland's unique past, as well as provide an opportunity to learn from international regarded scholars about some of the further challenges across the world in areas of governance, in areas of integrity, public accountability, and human rights. These are issues which directly relate to the Fitzgerald legacy. We believe the PhD scholarships provide a tangible way to ensure the legacy of Fitzgerald continues through a new generation of students and practitioners. And I'm very pleased that Marnie Manning, our first recipient of the Fitzgerald Scholarship from 2010, is with us tonight, and she's on the front row. So indeed, with dedicated PhD scholarships, we can provide investment towards future research into issues that are fundamental to the Fitzgerald inquiry, reforms, and in this small and tangible way, we can call attention to Tony's legacy, a legacy that has given so much to this state, to this country, and indeed this community. Ladies and gentlemen, please join me now in making welcome the Honourable Tony Fitzgerald.
Your Excellency, Chancellor, distinguished guests, and I hope that you will forgive me if I don't repeat the list that the previous speakers have referred to. Well, it's always interesting to come back. Janet said that Queensland was a different place. I have to tell you that in the rest of Australia, they think that Queensland is a different place. It's my great privilege and pleasure tonight to introduce Professor Hilary Charlesworth, our very distinguished lecturer. Before doing so, however, I've generously been permitted to delay you briefly with a few remarks. I wasn't going to speak, but the temptation was too great. As you know, Queensland recently overwhelmingly rejected another failed government and elected a new group of politicians with ambitions which, if history is a guide, might exceed their talents and experience. A pessimist, perhaps even a realist, might expect the new government to choose business as usual, followed by electoral rejection in due course, and the cycle of public disappointment to continue. However, the magnitude of the government's victory not only increases the risk of maladministration, but also presents Queensland with a real opportunity to raise political standards. Our Westminster system of government is an outdated and flawed model of representative democracy. The community elects representatives to whom it transfers its power to make rules and decisions for the common benefit, with all equally subject to the law. However, the established view is that under the Westminster system, the elected body or parliament is not obliged to act for the common good or treat all equally, or prohibited from enacting unjust, arbitrary or capricious laws. Individual and minority rights and interests are unprotected. The division and separation of powers which could provide checks and balances are blurred, and there are few controls on the improper pursuit or use of power. Centralised, effectively unfettered power might be efficient, but elected representatives and those seeking election are subject to common human frailties such as self-interest. Periodic financial corruption aside, political self-interest is focused on the acquisition, retention and exercise of power. In pursuit of those objectives, the Westminster system's flaws and vulnerabilities are routinely exploited by a few small, organised, largely unregulated and partially publicly funded groups or political parties between which the community is obliged to choose. Those who control these groups maintain and increase their power by pre-selecting favoured candidates who are willing to vote as directed, even against their consciences, appointing supporters to public positions, providing special access and influence to those who can provide reciprocal benefits, such as the wealthy, the media, and privileged supporters, and misleading voters and manipulating public opinion. One of the deceptions politicians use to distort the Westminster system is the theory of the so-called mandate. A person compelled to choose between two unsatisfactory options who rejects one does not necessarily endorse the other. A condemned person required to choose between hanging and a firing squad does not, by preferring one method, support his execution by the other. Similarly, a choice between abuse of power by Party A or Party B is not a mandate to abuse power. Statements of the Premier are encouraging, but much has been left unsaid, and the jobs for the boys' gravy train has already started. That's a shame. With its huge majority, the government could establish a new political paradigm simply by publicly acknowledging its limitations and committing itself to core ethical principles in a simple charter such as the following. Governments have to make decisions and take actions with disadvantages as well as advantages, and which sometimes benefit some people but harm others. The Queensland Government promises the people of Queensland that all decisions and actions will be taken for the common benefit and all appointments will be made on merit without regard to personal, political or other considerations. All persons will be treated equally and no person will buy or be given special treatment or superior access or influence. And the public will promptly be fully and accurately informed and will not be misled. However, self-interest makes it unlikely that political parties and politicians who benefit from the current system will initiate real change. Their likely mindset is that it's their turn. Political reform is a task for the community, which is in an excellent position to reshape Queensland politics following Saturday's rout. The electoral annihilation of the previous government broke the entrenched duopoly, for the time being at least, sent a clear message to political parties that they can't safely make gifts of Queensland electorates to party hacks, and created opportunities for local candidates who are known and respected in their communities. The internet provides a means to give substance and momentum to this altered political reality. If, as I hope, Griffith University proceeds to host a website containing brief biographies of all serious candidates for future elections, perhaps called Polypedia, voters will be able to scrutinise and compare the merits of rival candidates easily and quickly. Once voters can make properly informed choices, political parties will be forced to respond. A candidate's pre-selection by a political party will be only one factor, and political parties who don't pre-select on merit will pay a heavy price. The current toxic political culture can be radically altered by an infusion of public-spirited talent to counteract the mediocrity and venality of those power brokers and professional politicians whose life experience is limited to learning and practicing the dark arts of misinformation, secrecy and character assassination, and who pursue power by all available means, regardless of the public interest. Elsewhere, it would be time to say, that's my swan song. This being Queensland, I'm going to say, this was this cane toad's final croak. To your great relief, I now move to introducing Professor Charlesworth. Hilary is an internationally renowned expert on international law and human rights with a strong interest in gender. She was educated at the University of Melbourne and Harvard Law School, and her present appointments include Director of the Centre for International Governance and Justice and Professor of International Law and Human Rights at the Australian National University, Australian Research Council Laureate Fellow, Judge ad hoc on the International Court of Justice for the whaling in the Antarctic case, a member of a Paris institute, which I'm not going to name because I'd have to speak French and you'd all laugh at my accent, and a member of the editorial boards of a number of international law journals. Previously, Hilary was president of the Australian and New Zealand Society of International Law and chair of the Australian Capital Territories inquiry into a Bill of Rights, which led to the adoption of the ACT Human Rights Act 2004. She has published extensively, indeed enormously, held visiting appointments at a number of prestigious American and European universities, and was joint winner of the American Society of International Law's 2000 Golda T. Butcher Medal in recognition of her outstanding contribution to the development or effective realisation of international human rights law. In short, Hilary is a great Australian who contributes to society without self-promotion or the pursuit of power, wealth or celebrity. Please welcome Professor Charlesworth.
Your Excellency, distinguished guests, friends and colleagues, I'd like to start by joining Janet Ransley in acknowledging the traditional owners of the land on which we meet tonight, and I pay my respects to their elders, past and present. So it is a great honour for me to deliver the second Tony Fitzgerald lecture, and I'd like to thank Griffith University, particularly Professor Paul Mazerol and Janet Ransley, for their very kind invitation. And it's also a great honour for me to follow in the footsteps of the distinguished South African jurist Arthur Chaskalson, who delivered the first Fitzgerald lecture, and I've had a lot of enjoyment reading his lecture. I also want to emphasise, as other speakers have, that perhaps the most important aspect of this program is in fact the Tony Fitzgerald Scholarship Program, which enables a PhD student to work on a topic informed by the ethos of the Fitzgerald Inquiry. And I congratulate the current holder, Ms. Marnie Manning, and I encourage everybody here tonight to contribute generously to the continuation of that scholarship. Well, as everybody has said, except the man himself, Tony Fitzgerald's report on police misconduct and corruption in Queensland, delivered in 1989, was a landmark in public administration, not only in Queensland, but also, of course, nationally and internationally. And I think across Australia, Tony's name has become really a byword for integrity, insight and courage. In his remarks while introducing Arthur Chaskalson, and of course we've heard it again now, Tony Fitzgerald has made the important observation of the widespread, truly bipartisan culture of resisting open government and regarding political office as a legitimate vehicle for rewarding supporters. He also noted the appetite for a form of corruption in government is weak, dependent on principled leaders, a fearless public service and an informed media and public. And I found this photo of that over now 22 years ago of Tony handing his report to Mike Ahern, the then Premier. So those criticisms, though, made of in Queensland, of course, are absolutely global. And I think that the really important thing by having this regular lecture and the scholarship is to keep in our minds the events that led up to the Fitzgerald Inquiry and to recognise the risks of their repetition. I think that recognition of the risks of their repetition, which have been spelled out for us tonight, this would be the best possible tribute to the path-breaking work of a great Queenslander. Now, some of you, I found actually one other nice photo from that time. Some of you may well be wondering, now that the press have all left, what an international human rights lawyer can add to the reflections on the Fitzgerald legacy. At first sight, you might be thinking the finely grained Fitzgerald report, which dealt with very specific local patterns of police misconduct and corruption, might seem very far from the abstract and sweeping promises of international human rights treaties. But I'd like to suggest the Fitzgerald report can be seen as an excellent example of bringing lofty human rights guarantees to earth in a particular situation. It also, to me, underlines the systemic nature of public corruption and misconduct and the facile nature of the typical response that such phenomena, both human rights abuses globally and the issues in Queensland, were really the product of just a few bad apples. I think we can also, human rights lawyers can also learn a lot from the aftermath of the Fitzgerald report, which shows that the outcomes of fearless inquiries do not automatically generate change. Indeed, a backlash is much more certain. It will be relentless, even if it's subtle. Progress, in other words, depends on constant monitoring and pressure, the engagement of all of us. Tony Fitzgerald's work also illustrates the personal price that's often paid by human rights defenders. Your card, as Mr. Fitzgerald noted in 2009, is permanently marked. Well, the question at the heart of my lecture is how we can get the international human rights system to work better. This is a picture of flags outside the Palais des Nations in Geneva, a place very familiar to our governor, who served as the head of the Australian delegation there. What I want to do tonight is to start by sketching the outlines of the international human rights system and then identify some of the gaps between promise and practice. I plan to draw on some concepts from the field of regulation, particularly the notion of ritualism, to help explain why these gaps between promise and performance exist. And then I want to end up by considering ways that we might be able to counter this ritualism and make the international human rights system more effective. Well, the international human rights system comprises a complex set of institutions, treaties, declarations and practices at both the global and regional level. This, of course, is a photo, although some of you may not recognise him, of Doc Evatt, the Australian Minister for External Affairs, signing the UN Charter in 1945. And it was the UN Charter, the document that Doc Evatt is signing there, that contained quite a historic commitment, and these are the words of the Charter, that the UN's role was to promote and encourage respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language or religion. Well, the international human rights system today comprises, thank you very much, 9 core human rights treaties, including 2 general treaties. These are the International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, both adopted in 1966. And then there are treaties devoted to particular human rights and groups, for example, the Convention Against Torture. And then there are treaties that focus on particular people, the Convention on the Elimination of Discrimination Against Women and the Convention on the Rights of Persons with Disabilities. So we can see then there has been, in the words of one commentator, a cascade of words setting human rights standards over the last 60 years. So these 9 treaties, and I've got them in somewhat truncated form there with the date they're adopted, and then the other figure that you've got there is the number of countries that have actually ratified, that have become parties to all these treaties. So you can see by a quick look at this list that the UN human rights treaties have really attracted widespread participation. So all of the UN's current 193 members are party to at least one of the 9 core treaties, and 80% of members of the UN have ratified 4 or more. And you can see there that the most ratified convention is the Convention on the Rights of the Child, that has 193 parties. Interestingly, the United States and Somalia are the only 2 countries that are not parties to that convention. So you might wonder, well, if there are 193 members of the UN, how does that explain 193 parties? And that's because the Holy See and the Cook Islands, 2 non-members of the UN, have actually ratified the Children's Convention. That's for Trivial Pursuit buffs. But we can also see that the 2 major covenants have got serious figures, 160 and 167 parties. Now, compared to any other treaty systems, such as environmental treaty systems, arms control or resource treaties, these are seriously impressive figures of participation. Now, the international human rights architecture that's implementing these treaties is very complicated. First of all of those treaties have treaty bodies that monitor them. They're made up of experts. And I have here a photo because it's got an Australian in it. These are members of the committee that monitor the Convention on the Rights of Persons with Disabilities. And the person, I guess, on the extreme left there is Professor Ron McCallum, the former Dean of Sydney Law School, who's currently the chair of that particular committee and serving with great distinction. But he's serving not as an Australian, he's serving as an expert in that area. So that's the first way that all these treaties are monitored. You have these expert bodies overseeing them. Then the second part, if you like, of the human rights architecture is a political body, and this is a bird's eye view of the Human Rights Council. I'll be talking more about this in a moment. This is it's room 20 in the Palais des Nations, with an extraordinary ceiling donated by the Spanish government, painted by Miguel Barroso, a famous Spanish artist. If you're actually in the room, it feels as though you're in a sort of a Technicolor cave, because it's got these stalactites that come down towards you. I was told they're only made of paper mache, so they're not threatening life. But that's the Human Rights Council, and this is a body to which states are parties. And the third major element in the UN human rights architecture is the Office of the UN High Commissioner for Human Rights, and here is the current High Commissioner. That's Justice Navi Pillay, a very distinguished South African jurist. And her office is is responsible for the promotion of human rights throughout the UN system. There's also, I just mentioned in passing, a very interesting system of regional human rights architecture, the European Convention on Human Rights with the European Court. The European Convention was adopted in 1950. We have an Inter-American Court of Human Rights. We have an African Court of Human Rights. There's an Arab Charter on Human Rights. And in our region, there is no comparable body, but ASEAN has recently established an intergovernmental panel on human rights. So the point I want to make is that there is considerable architecture, there is a lot of standards. But when we actually look at the implementation of international human rights treaties, we see a great gap between the fine standards and the fine institutions and what actually happens on the ground. Just to take an example that's in the news at the moment, Syria, for example, is a member, is a party to almost all the major human rights treaties. And yet, of course, as we know, this hasn't constrained the Assad government from serious violations of its people's rights. Or take recent examples from Afghanistan and Australia. Afghanistan became a party to the Convention on the Elimination of All Forms of Discrimination Against Women in 2003. And yet in 2009, the Karzai government adopted a law on personal status which requires Shiite women, it only applies to the Shiite community, to obtain a male relative's permission to leave their house, to seek employment or education, and requires them by law to accede to their husband's sexual demands. And this image is actually an image of a women's demonstration in Kabul as a result of the adoption of that law. But then coming closer to home, Australia has been a party to that same treaty, the Convention on the Elimination of Discrimination Against Women, since 1983. But we just have to look at Section 37 of our Sex Discrimination Act to see that it allows religious schools and institutions to discriminate on the basis of sex and marital status where it is consistent with religious doctrine to do so. Now, what happens when countries are clearly violating international human rights treaties? The political organs of the United Nations are generally reluctant to take stronger measures, such as sanctions, in response to human rights abuses. We also see that human rights norms have quite precarious status within international institutions themselves. And there have been a number of recent studies showing that the World Bank and indeed the UN bureaucracy itself is very, very slow to take these standards into account. So for all these reasons, the fine standards and yet the very, very poor implementation, the UN High Commissioner for Human Rights has recently said, and I quote from her, "There persist huge gaps between lofty pledges and national realities of human rights protection." Well, how can we understand the dissonance between international human rights guarantees and their weak implementation? Now, the so-called realists, the realist school in international relations, might simply say that this is a product of state interests and power relations. The argument would go something like, well, countries comply with treaties only insofar as they deem them to be in the national interest, or if they are coerced into doing so by more powerful states. That's one approach to it. Some other scholars have adopted what they call an expressive theory of treaty ratification, arguing that treaty ratification is a low-cost method for countries to express support for the principles that might be contained in human rights treaties while avoiding any practical action. And a lot of these scholars have used statistical analysis to chart the relationship between treaty acceptance and state behaviour, finding very little correlation between the two. Then, of course, because it's academia, there have been others who've criticised that explanation in turn, pointing out that, well, treaty participation certainly grants no immunity to criticism. So they've questioned the so-called expressive theory. There are other variations on some of these theories. There's a school of scholars who argue that treaty participation can be seen to improve human rights practices in democracies, but not necessarily otherwise. And then there's a very interesting recent book by the Harvard International Relations theorist Beth Simmons, who argues that human rights treaties are really primarily useful as a tool for civil society to mobilise against human rights abuses. But after sort of surveying a lot of this literature, one can come to the conclusion that a lot of the literature that specialises in treaty implementation shows that international human rights law is like a smoke detector that stops working whenever a fire gets really large. So one response to this problem is when we look, well, what is the way ahead? There's a lot of literature on the need for institution strengthening and tougher enforcement mechanisms. So, for example, there's a great body of scholarship which calls for streamlining the UN treaty bodies, which are cumbersome and inefficient in many ways. But what I'd like to do tonight is to propose a different type of analysis of the international human rights system, drawing on regulatory theory. The concept of regulation is much broader than law, and it's been defined as, and I'm quoting here from one of my colleagues, John Braithwaite, the intentional activity of attempting to control, order, or influence the behaviour of others. So in other words, regulation encompasses political, social, economic, and psychological pressures just as much as legal rules. In other words, it doesn't privilege law as a way of influencing behaviour. Now, it seems to me a fruitful idea when we're considering the international human rights system in this field is what's been called regulatory ritualism. Ritualism is one of the 5 types of adaptation to a normative order identified by the sociologist Robert Merton back in 1968. And the other 4 types of adaptation to a normative order are conformity, innovation, retreatism, and rebellion. But I'll leave those aside while I focus on ritualism. So ritualism, as a response to a normative order, has been defined, and again this is a quote, as an acceptance of institutionalised means for securing regulatory goals while losing all focus on achieving the goals or outcomes themselves. So it's accepting the institutions to achieve the goals, but losing all focus on achieving the goals or the outcomes themselves. So my colleagues, John and Valerie Braithwaite and Tony Mackay, I first came across this idea in reading their work on regulation of nursing homes. So they've published, I think, a very important book looking at the regulation of aged care in the United States, the United Kingdom and Australia. And what they did in a very lengthy study was to find that nursing home operators very rarely actively resisted regulation. It was much, much more common for operators to avoid confrontation with regulators and to agree to the language and techniques of regulation. For example, one way of doing it was by changing a policy. So that strategy really paid dividends. It usually favoured the preservation of the status quo, both because the regulators didn't have sophisticated follow-up mechanisms and because the new plans or policies could be observed in a perfunctory way. Now, before I develop that point in the context of the international human rights system, let me very carefully distinguish the idea of rituals from ritualism. So, human rights rituals and human rights ritualism are quite distinct. So, for example, and this picture here displays a ritual, a head of state signing a human rights treaty can be a valuable, even an inspiring ritual. But if nothing happens beyond placing the signature on the page, we have witnessed ritualism. Now, regulatory scholars who are concerned with ritualism do not oppose rituals. Indeed, rituals can be very important steps on a journey towards substantive transformation. One of the paradoxes about regulatory scholarship on the problem of ritualism is that it sees emotionally engaging rituals, particularly restorative justice rituals, as potentially generating politically engaged transformation. But the suggestion I want to make is that regulatory ritualism is a powerful, but I think really underexplored feature not just of nursing home regulation, but also of the international human rights system. Rights ritualism, I want to suggest, is a much more common response than an outright rejection of human rights standards and institutions. And we've seen that just from the figures, the very large number of countries that have accepted the international human rights treaties. Ritualism, in other words, is a technique of embracing the language of human rights while deflecting human rights scrutiny and avoiding accountability for human rights abuses. Practices of ritualism can include perfunctory reporting to international human rights bodies, minimal amendment of domestic laws to remedy human rights breaches, and another favoured technique of ritualism is invoking claims of culture to undermine international standards. For example, Afghanistan's accession to the Convention on the Elimination of Discrimination Against Women in 2003, that I referred to earlier, was the result of considerable international pressure. But the 2009 Personal Status Law that I discussed earlier, which clearly breached Afghanistan's international obligations, deferred to local pressures from Shiite clerics. Similarly, I would suggest Australia's breach of the same convention in relation to religious sex discrimination was the product of pressure from the churches here in Australia, our own Australian religious culture. The international community has tacitly endorsed all forms of ritualism, perhaps, I suspect, because it's the path of least resistance in a political system that's inhospitable to human rights enforcement. So ritualism in the human rights context can be understood as a technique to manage the theoretical equality of all UN member states. The idea, in other words, that Afghanistan is in theory as autonomous as the United States. And it's a way of managing that theory with the reality of unequal political power. What I'd like to do now is to consider ways in which human rights ritualism can be countered, focusing on a particular mechanism of the UN Human Rights Council known as the Universal Periodic Review. So I'd like to begin by telling you a bit about the UN Human Rights Council. This image is in fact the UN General Assembly at the moment when the General Assembly voted in 2005 to actually establish the UN Human Rights Council. So in the early 2000s, the then Secretary General of the United Nations, Kofi Annan, embarked on an ambitious UN reform process. Now, one aspect of his reform process was reform of the UN's engine room on human rights, which was called the Commission on Human Rights. Both the global north, the developed world, and the global south, the developing world, had come to regard the Commission as biased. For example, the United States had been extremely irritated by the Commission's criticism of human rights violations in the war against terror, and also it had been very irritated by the Commission's criticism of instruments such as the Multilateral Agreement for Investment. And then for their part, the developing world, the third world, many of its states resented the fact that the practices of Western countries generally escaped scrutiny. They felt all the focus was on them. Now, at the time, the US ambassador to the United Nations, and you can see him sitting here, this is a picture of the US delegation at this moment, and John Bolton, who's a famous figure and name, you can see him sitting there with the moustache. He said at the time when the Commission on Human Rights was being wound up and there was talk about a new body, he said at the time, we want a butterfly. We're not going to put lipstick on a caterpillar and declare it a success. So in this quest for a butterfly, the United States said that the only way to get a proper human rights body was for a body with a very small membership, just 20 states, who would fit the mould of Western-style liberal democracies. Well, in the end, that argument didn't prevail. The Commission had 53 members, and in the end, the new body that replaced it, the Human Rights Council, has 47 members. Now, its seats are allocated according to regional groupings, and in the way that this has happened at the UN, this has given the Human Rights Council, it gives considerable weight to non-Western countries, because, of course, they form the majority of UN members. Well, the Human Rights Council, whether it was a caterpillar with lipstick or a butterfly, it was launched with much optimism in 2006, and the Commission was abolished. There were some important changes to voting procedures in the new Council on Human Rights, and they were designed to discourage states with bad human rights records from being members of the Council. For example, in theory, although this hasn't actually happened in practice, members were going to be elected individually rather than on regional slates through a system of secret ballots in the General Assembly, where they had to attract votes from a majority of General Assembly members. And there was also capacity for the General Assembly to suspend states over human rights abuses. And here, because he's a Queenslander, I thought you would like to see him in action. Here is Kevin Rudd as Foreign Minister talking at the Human Rights Council, urging that Libya, which was a member of the Human Rights Council, be suspended last year. So this is an important, if you like, form of quality control in the Council. A major difference between the Commission on Human Rights, the old body, and the new one, the Human Rights Council, is a new procedure to monitor human rights, and this is really what I want to focus on, which is called the Universal Periodic Review, which began in 2007. Now, the Universal Periodic Review involves every member of the UN, all 193 members of them, being subjected to human rights scrutiny every 4 years. So that works out roughly about 48 countries per year. Now, although you might be thinking that's an extremely modest development, it's a really significant step in terms of international human rights scrutiny. Since the inception of the United Nations, human rights have been a tool of international politics. Typically, they were used as a tool by developed countries to criticise developing countries, with very little sense that wealthy developed countries could also breach human rights standards. And so the idea of the Universal Periodic Review meant that human rights questions could be raised not just in relation to the usual suspects, such as Myanmar, Cuba, North Korea and Zimbabwe, but also in relation to self-styled gold-plated democracies, such as Australia and the United States. So in other words, the Universal Periodic Review undermines the sense that there are some countries with incorrigibly bad human rights records and some countries of impeccable human rights value. So the question I'm interested in this lecture is, can this new mechanism, the Universal Periodic Review, whose goal is to hold all UN members to account for human rights law, can it provide an antidote to regulatory ritualism in human rights? So I'd like to make, first of all, some general observations about the Universal Periodic Review, which has now completed its first 4-year cycle, and then I want to focus on Australia's experience of the Universal Periodic Review as a case study of the process. Overall, I think we can see that the Universal Periodic Review has really had some significant success. It's allowed a broad public review of human rights implementation, and what's really significant, not one state, not one of the 193 states has refused to participate, although some, for example South Africa, ignored the relevant timelines. But every country agreed to submit itself, even North Korea, Zimbabwe and so on. The fact that the Universal Periodic Review involves states reviewing other states, which is a very interesting manifestation of peer review, something we in universities are very used to, means that it's taken much more seriously, I think, at the governmental level than review by the UN treaty bodies, which are made up of independent experts. The Universal Periodic Review requires states to justify departures from human rights norms in a multilateral setting. There's a requirement that all states consult with members of civil society before finalising their report to the review, and this has been taken seriously in some cases. The publicity that's given to the Universal Periodic Review, compared to the very quiet work of the treaty bodies, also adds to its impact. And I was very struck by the fact when China was having its Universal Periodic Review, apparently the internet failed in China because it was directly being broadcast, which shows to some extent the power of the internet in this respect. So those are the positives. On the other hand, the Universal Periodic Review has also been limited by the fact that it is essentially state-run scrutiny. And the process relies on submissions, dialogue, report and recommendations, and these are all affected, of course, by regional and global alliances. Now, in the first 4-year cycle, the 2-hour public dialogue with a country being reviewed could easily be manipulated to a certain extent by stacking the speakers list with friendly countries. So in the 2 hours allocated, and they had time limits, there was a sense you could get 55 countries could make a question in those 2 hours. So it began to be incredibly important. Some countries engaged in stacking the speakers list to make sure that the first 55 countries on the list were countries that were very, very friendly to preclude any tough questions being asked. And while I was doing some field work last year in Geneva, I came across some extraordinary accounts of the politics of the speakers list because it was run on a first-come, first-served basis. Anyone who's managed a junior soccer team will know that's a crazy way to run anything, but the UN hasn't worked that out to the second way round. So hapless third secretaries to Geneva missions were required on occasions to sleep overnight in their cars to ensure that their country would be high on the speakers list. And there were also some verified stories of some countries inviting friendly countries only to arrive early by providing breakfast in the car park. And there were 2 countries, and I won't name them, but you can perhaps guess who they were. One country provided rum for early arrivals, and the other provided vodka. So the fact that the speakers list could be stacked is reflected in some of those country reports and recommendations. And you can tell the ones that were stacked because their reports are replete with praise from friends. Dear country X, please tell us the secret of your vast human rights success. And very, very few tough questions. When we look at the country reports that were filed, we see that there's generally very little self-criticism. And some countries just ignored very well-documented human rights issues. And a striking one was South Africa's report, which simply didn't refer to HIV/AIDS, a major public health issue in South Africa, as a problem at all. There were also plenty of examples of countries pleading special circumstances. Yes, we might have violated human rights, but there were special circumstances. For example, the United Kingdom relied on the threat of terrorism to explain restrictions on the right to a fair trial, as did a number of other Western countries. I want now to turn to Australia's experience of the Universal Periodic Review. We appeared last year in this exercise on the 27th of January 2011, sandwiched between the appearances, interestingly, of Myanmar and Georgia. Well, I think many of the aspects of the process were very positive. I think it's fair to say that the Australian government consulted extensively with civil society on its national report to the Universal Periodic Review, and all of these documents are available very easily on the web. A draft report was prepared and the government sought public comment from the public as also states and territories. And the report honestly acknowledged some problems in Australia, for example, the lower life expectancy of Indigenous Australians and the fact that women's earnings are on average lower than those of men. But perhaps inevitably, the Australian report also put a very positive gloss on human rights implementation in Australia. So it didn't dwell on the fact that the protection of human rights in Australia is a complex and sometimes contradictory patchwork of laws and practices. It briefly acknowledged the work of Frank Brennan's National Human Rights Consultation, but it did not note that it had rejected an important recommendation of that committee, the introduction of a legislative Bill of Rights. I think this would disappoint Arthur Juskelson, whose 2009 inaugural Fitzgerald lecture argued strongly for such a move. Now, the process of preparation of the report prompted some excellent analysis by the Australian Human Rights Commission, which pointed to a number of pressing human rights issues for Australia, including our treatment of refugees, Indigenous people and prisoners. And there was also a terrific report by a joint coalition of Australian NGOs, human rights NGOs. And they supplied this material, and you can see it clearly reflected back in some of the questions that Australia was asked. Australia took the opportunity when it appeared before the Human Rights Council to make some valuable new commitments. For example, establishing a full-time race discrimination commissioner. And we also promised to create a systematic process for review of Australians' reservations to human rights treaties. Well, 70 countries put their names on the speakers list. There's no evidence that Australia offered anything in the car park before this. But there was only time for 53 countries to make 2-minute interventions. And what's striking when you read them through is how consistent those questions were. So the major themes, a lot of countries congratulated Australia for the Kevin Rudd's apology to Indigenous Australians. There was a consistent theme was concern over Australia's treatment of its Indigenous peoples. Another major one was the rights of refugee and asylum seekers. Protection of children's rights was another major concern. And a number of countries, including Canada, France, Jordan, the Ukraine, Timor-Leste and Norway, were critical of the government and asked why it hadn't more fully implemented the recommendations of the Brennan National Human Rights Consultation. Some countries, for example, Slovenia, argued for the establishment of a national compensation tribunal to compensate Indigenous children who'd been removed from their families. Sweden raised the question of excising of Australia's excision of territory to enable special regimes for offshore processing of asylum seekers. And a number of countries raised the issue of Australia strengthening its sex discrimination laws. These included Israel and Norway, South Africa, Japan and Botswana. And Norway indeed proposed that Australia should have a target of 40% representation of women on private and public sector boards. A number of countries, including New Zealand, Colombia and Switzerland, emphasised the need for the Commonwealth to introduce legislation to prohibit discrimination on the basis of sexual orientation, and Norway boldly called for amendments to the Marriage Act to allow same-sex partners to marry. China asked about systematic racism in the media and the internet. Morocco asked about funding for Islamic schools. But when you read the record, and again, it's all there for you to read on the internet, I think it was striking that the boldest criticism of Australia came from Iran. And it was concerned, perhaps we might think in light of recent events presciently, about the use of tasers by police, and also it raised the substandard conditions in Australian prisons. Well, what happened was that there were the Human Rights Council collects all these questions, it makes them into a draft report, and finally there are 145 recommendations. This is essentially a compilation, and they really divided into the categories that I've referred to earlier, although some of them were cast quite differently: Indigenous people, refugee and asylum seekers, better implementation of human rights through a National Bill of Rights. There was particular concern with the rights of refugees. This was raised by more countries than any other issue, and this was a matter of considerable concern that came through many of the interventions. Well, back home in Australia, the then Attorney General, Robert McClelland, tabled this draft report in Parliament. And while welcoming the tabling, the Shadow Foreign Affairs Minister, Julie Bishop, was concerned in particular with the fact that Iran had questioned Australia on a number of issues and said that she found criticism by Iran of anything about Australia's human rights records, she used the word somewhat galling. Now, I think that response, and that response was made by some parts of the media too, how outrageous that a country like Iran, not known for its human rights record, indeed on the contrary, criticise a country like Australia. But I think while the response is understandable to a certain degree, the charge of hypocrisy is all too easy to make in the human rights area. Of course, no country at all has a perfect human rights record, and the potential of the Universal Periodic Review depends on tough scrutiny from all UN members, whether we like them or not, and the ability to answer concerns of friends and ideological foes. Well, Australia then prepared its response to the draft report, and Australia then presented that back to the Human Rights Council in June last year, after consultations with the states and territories and so on. Now, the response was positive in some respects. We accepted, there's quite a politics, I think Australia said we accepted 90% of the recommendations, but it's very interesting, of course, it depends how many recommendations there were, and some countries actually have engaged in a politics of recommendations. If they're planning to accept recommendations, they want them all itemised and detailed out so they can say they've accepted a large portion of them, and then group together are the recommendations they don't accept. So there's quite some interesting politics of which ones. But Australia, to its credit, did accept a large number of the recommendations made. But in some ways, I think the Australian report was also disappointingly defensive. And we also outright rejected some major recommendations with almost no explanation. These included a call to enact a Human Rights Act, the call to compensate the stolen generations, and the call to end mandatory detention of asylum seekers. However, what's been very interesting, even though that was perhaps disappointing, the government response in some respects, what's really striking is that this has galvanised civil society in Australia, and the very broad human rights NGO coalition has, I think, very effectively been able to use the Universal Periodic Review report and process to bring pressure on the Australian government, especially on the issue of detention of asylum seekers. And so because the Australian delegation, when it was sitting in the Human Rights Council, made some very general statements with appropriate weasel words in them. Of course, the Australian government is doing everything practicable to end mandatory detention. The NGO coalition seized on these bland words and criticised them for being inaccurate. And the NGO coalition, I'm sure this caused some sleepless nights in DFAT, wrote to UN delegations criticising the Australian government's assurance that it was committed to treating asylum seekers and refugees humanely and fairly, and also criticising the Australian government for saying that detention was only used as a last resort and for the shortest practicable time. So the NGO letter, which was circulated to all delegations, pointed out the truth that in fact Australian law allows mandatory indefinite detention without judicial oversight. It also countered the Australian delegation's claim that children and their families would not be detained in immigration detention centres, noting that when it wrote the letter in April last year that over 1,000 children were being held in secure facilities with no freedom of movement. Well, what might then we draw from the Australian experience of the Universal Periodic Review? Does this new process provide some sort of counterweight to human rights ritualism at the international level? Now, I think overall we can say that the Universal Periodic Review has proved to be valuable. And I think that it really has raised the profile of human rights issues at the international level. It's really significant that powerful states be subjected to the same scrutiny, perhaps more than less powerful players. The Australian experience, as I've suggested, however, also shows up some of the weak spots in the process. For example, the nature of the country's recommendations. Some are very general and vague and very hard to implement. Some are quite precise but can be circumvented by reference to local conditions or special circumstances. One concern that's been raised is about the interaction of this new intergovernmental process with review by the human rights treaty bodies. And there are signs that now that some countries much prefer the Universal Periodic Review by their peers to resist, they use those reviews to resist the often sharper and more expert criticisms of the expert treaty bodies. The next cycle of the Universal Periodic Review. This is a picture of the Human Rights Council in session, and you get a better view of that glorious roof there. The second cycle is going to begin in the second half of this year, and it's going to focus on implementation of the recommendations of the first review, and this is going to generate important information to assess the efficacy of the process. But there's a lot of debate because it's been suggested that the second review should only focus on implementation of accepted recommendations, those recommendations accepted by states, which would effectively allow states to limit the scope of the review by simply rejecting recommendations in areas it doesn't want to discuss. Now, a close observer of Australia's engagement with the Universal Periodic Review might note that the questions that Australia itself puts to other countries during the Universal Periodic Review, they most often revolve around legal protections given to human rights. I was very struck by this reading through the records because it seems to me that that same question, legal protection of human rights, could very reasonably be turned back on Australia. And so, in the spirit of Arthur Chaskalson's lecture 2.5 years ago, we could ask, why haven't we taken the advice of the Brennan Committee after the amount of public money and resources spent on it and the extensive consultations around Australia, to adopt legislation that provides a coherent and clear human rights protection in Australia. But as I've suggested, perhaps the most significant outcome of the Universal Periodic Review in Australia, our own country, has been the active work and advocacy of the NGO sector. And I think that this is going to have long-term benefits for the quality of human rights scrutiny in Australia. Well, in conclusion, I've argued that understanding the weaknesses of the international human rights system through a regulatory lens allows us to identify some of the elements of human rights ritualism, the techniques of avoiding human rights regulation while appearing to accept it. What are some ways forward? How can we discourage ritualism and encourage self-regulation and commitment with respect to human rights norms? While international legal scholars generally tend to emphasise greater rule compliance as the answer to failures in the human rights system, the regulatory literature offers the idea of continuous improvement. And this, of course, would emphasise incremental, constantly monitored steps rather than expecting great leaps forward. And it can be achieved, in the words of John Braithwaite, by moving from a blame culture to a learning culture. So what does this mean in the field of human rights? It seems to me that above all, this means that we have to develop the capacity of local actors above all, that international human rights has to be less about global standards emanating from on high, trickling down, than there being some capacity of local groups to actually influence the international human rights system. So the challenge is to translate human rights in ways that can be invoked by local people, by local groups, by communities, connecting the international standards to specific political and social structures, and understanding human rights practices in themselves as cultural practices, rather than a top-down regulatory regime. And the legal anthropologist Sally Ingle-Merry has termed this process vernacularisation. It seems to me in this process, the role of the non-government sector of civil society is absolutely critical. Civil society can be empowered by a country's treaty ratification, even if a state itself fails to implement it. And another, and of course an adjunct, a critical adjunct to the goal of self-regulation in human rights, is the very important role played by a free and independent media. Other tactics to counter ritualism include the identification of issues that even a human rights defiant state may consider a problem, and building on that concession to other human rights concerns. And I think a really nice example of that was the work actually done by Michael Kirby when he was the UN, the Secretary General Special Representative to Cambodia in the 1990s. And I think he very cleverly, he was encountering a fairly hostile human rights environment, but he obtained support from the Cambodian government to work on HIV/AIDS as an issue it was willing to concede was a major problem, and then branched out from there to other areas of human rights. At the same time, the Universal Periodic Review process illustrates the power of human rights rituals or human rights performances. Whatever else, despite some of its failures that I've pointed to tonight, we know that because countries are doing things like trying to stack speakers' lists, stopping the internet when their country is up for review, countries care about the process and how they're going to emerge from it. The challenge is to harness the positive, transformative potential of the rituals and thus undermine the ritualism. Well, one of the most significant aspects of the Fitzgerald report, as we've already been reminded tonight, was its recognition that public corruption in Queensland required systemic structural responses. The punishing individuals was not enough, and that entrenched attitudes had to change. And so, of course, rather than proposing a single anti-corruption body, Tony Fitzgerald envisaged a network of institutions that would work to achieve these ends. And he recognised also that these institutions had to be checked against abuse of power. And it seems to me that those insights apply equally to implementing human rights. It requires a learning rather than a punitive culture, as well as a vibrant system of network checks and balances to guard against arbitrary power in any form, not always by governments. There can be arbitrary power in civil society as well. And so in celebrating Tony Fitzgerald's great contributions to public life tonight, I think we also have to be conscious there's been a lot of focus on the one man, but we have to be conscious that we can't just rely on the capacity of extraordinary individuals to improve our world. Their appearance is, to a certain degree, a matter of luck. What we need is not one, but many Tony Fitzgeralds. This is my last slide. Sorry, that's the Australian delegation at the UPR, and that's the NGO delegation. And that's the UPR again. But here's my final slide. What we need is not one, but many Tony Fitzgeralds in all areas of public life. People who are humble, courageous, imaginative, and passionate about the fabric of our society, who are willing to take on what Norman Mailer, and this is a famous, I think, a quote that Tony has invoked in a couple of different contexts, what Norman Mailer has called the heavy labour of maintaining a democracy, who are willing to do that with us. So I think it's our responsibility as educators, parents, colleagues and as citizens to support and nurture these qualities in all those around us.
Thank you very much, Professor Charlesworth, for that very inspiring lecture, and in particular, I think, for the way that you've encouraged us to think about the issues of good governance and ethics and rights and justice on a global level and connect them to how we've thought about them for so long in Queensland at a state and parochial level. And that's a very interesting insight for us to take away. Ladies and gentlemen, as Professor Charlesworth has alluded to, at Griffith University, we're committed to maintaining the Fitzgerald vision and the Fitzgerald legacy. We're committed to nurturing the next generation of scholars and critics and people who can make a positive contribution of the type that Tony Fitzgerald himself has made, of the type that Professor Charlesworth has made. And it's for that reason that we've established the Tony Fitzgerald Scholarship to support the next wave of scholars to assist in that process. We've made mention tonight of the first scholarship that's been awarded to Marnie Manning, who's pursuing her PhD at the moment. And I'd like to take the opportunity tonight to announce that we will be opening applications for a second scholarship in the very, very near future. Of course, I would also like to remind you that you have the capacity to contribute to this process. There are cards that have been distributed or are being distributed tonight which enable you to make contributions to the scholarship fund. And I'd like to encourage you to think about making a contribution to that fund. I'd also like to acknowledge and to thank Professor Charlesworth by giving her a token of our appreciation and the appreciation from Griffith University for coming, making the trip to the far north and giving us the benefit of your insights. And in a moment, my assistant a memento of your time at Griffith. Thank you very much. So that concludes the proceedings for tonight. Thank you very much, ladies and gentlemen, for coming, and thank you again to all of our speakers tonight.